Mrs. Fuller, Mr. Silva has joined us by Zoom. And Ms. Gonzalez Gutierrez is also present, physically present here in the courthouse. We have made arrangements for her to be able to participate remotely from here in the courthouse when we get to her case, which would be shortly after we finish Ms. Brooks and Mr. Wesley's case. Since Mr. Silva has joined us,
physically present here in the courthouse.
Sorry for that feedback. I took care of that now. Do you desire to dispose of his case today, or do it when we have it rescheduled tomorrow morning?
Your Honor, I actually think it's tomorrow afternoon, set for a plea.
It is. I'm sorry, tomorrow afternoon.
Right, and I don't have any pretrial matters. I'm comfortable just having that plea tomorrow.
All right, Mr. Silva, do you understand that we will hear your case tomorrow afternoon? I believe it's set at 3 o'clock.
Judge?
Yes.
I'm sorry, if I could interject just real quick. I think Jara, working with Jeannie's office, took care of preparing the plea papers for today as well, just in case if we had time to accomplish a plea in Mr. Silva's case today. And I've signed those papers just a few minutes ago, so if there's time, I've got time to do it if everybody else does.
Ben, I'm sorry.
Go ahead. No.
I have another hearing at 3 o'clock.
Okay.
Well, there's a possibility we could get to it and get it disposed of before 3 o'clock. But I'm also fine in having him come back tomorrow afternoon. I'm just trying to accommodate your schedule, Mrs. Fuller.
Oh, either way is fine with me, Judge. I just have to be on a 3 o'clock hearing with Judge Phelan, which is supposed to run from 3 to 5. So it would be kind of pushing it because it's already 1:30, but.
Okay. Mr. Smith, will you be available tomorrow for a?
Yes, absolutely.
All right. Then, Mr. Silva, I note that you are present, but we're going to hear your case tomorrow afternoon at 3 o'clock or just before 3 o'clock. And so we will give you and Mrs. Fuller, I think we already have, new information on how to get into the Zoom hearing tomorrow at 3. Do you understand? Mr. Silva, do you understand?
Yes, Your Honor.
You have any questions?
No, Your Honor.
All right, I will see you tomorrow on Zoom at 3 o'clock.
Okay, thank you. You have a good day.
Thank you. All right, let's continue. Ms. Brooks and Mr. Wesley, I was in the process of announcing that this hearing is being conducted by remote video teleconferencing technology, as well as being live streamed on the court's YouTube channel in order to provide access to the public and to comply with Supreme Court and Office of Court Administration mandates. The court understands that the defendant desires to enter a plea of guilty to the charges in the indictment pursuant to a plea agreement. So in cause number 10,837, styled the State of Texas versus Alonzo Jovan Wesley, I call upon the state. What says the state?
State's ready, Your Honor.
And what says defense?
Defense is ready, Your Honor.
Are you Alonzo Jovan Wesley?
Yes, sir.
Mr. Wesley, an indictment has been returned into this court charging you with a state jail felony offense of possession of a controlled substance. You have the right to have that indictment read out loud to you here in open court. Do you wish to have someone read that indictment to you?
No, sir.
Do you understand that it does charge you with possession of a controlled substance as a state jail felony charge?
Yes, sir.
Then understanding that charge, how do you wish to plead? Guilty or not guilty?
Guilty.
Do you understand that you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty. And further, you have the right to not have it used against you or held against you in any way just because you might exercise that right. Do you understand that?
Yes, sir.
You also have the right to have a minimum of 10 days notice of the charges pending against you. Looking at the court's docket entries and going upon my own memory, I know that you have had more than 10 days notice. Nevertheless, I would grant you some additional time if you wish to have it. You also have the right to have a jury hear your case, and that's true even if you plead guilty. Now, we're going to have a jury trial this month. We are still having jury trials, even though we are not having our non-jury hearings in person. And that's why you are not in the courtroom right now, but instead are in another place on the Zoom website going through a computer. Do you understand you have the right to a jury trial?
Yes, sir.
I have been handed a document entitled Waiver of Defendant that has the signature. It looks to me like it says Alonzo Wesley. Did you sign a document entitled Waiver of Defendant by assigning the name Alonzo Wesley?
Yes, sir.
Did you know that that document said you were giving up the opportunity to have more time and you were giving up the right to have a jury trial when you signed it?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Ms. Brooks, your signature is also on this document. Are you telling me that you're joining your client in the waiver of these rights?
Yes, Your Honor.
And Mr. Smith, your signature is likewise on the document. Is that evidencing the state's joinder in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, Mr. Wesley, I announce that I will accept those waivers and we will proceed with this plea hearing. And I need to discuss other matters with you, some other rights and admonitions that I need to cover with you, Mr. Wesley. First, let's talk about the range of penalties for a state jail felony. State jail felony range of penalties runs from 180 days up to 2 years in a state jail. And it also carries the possibility that a fine could be imposed. And if imposed, that fine could be in any amount up to $10,000. Do you understand that's the possible range of penalties you face if you were to be convicted of this charge?
Yes, sir.
I've already mentioned that I'm aware that a plea agreement exists in your case. Let me tell you that I do not have to follow that plea agreement. I do have to let you know if I'm going to follow the plea agreement or not. And I will do that. If I decide not to follow your plea agreement, the law says you then would have a right to withdraw your plea of guilty. Stated more succinctly, if I don't follow your plea agreement, you can take back your plea of guilty and it won't be used against you. And it won't be used when we go to trial in your case, which will be soon hereafter. If I do follow your plea agreement, then under the Texas law, I would tell you that you are bound by the terms of the plea agreement. You cannot get out of those terms just because you don't like those terms anymore, or you couldn't get out of the terms of the plea agreement by appealing your case, which is different than the normal rule. The normal rule is you have the right to appeal. But if a part of your plea agreement says you give up the right to appeal as a part of the agreement, it means what it says and you cannot appeal. And I've looked at your plea agreement and it says that you're giving up the right to appeal as a part of the agreement itself. And so, as I said, if I follow your plea agreement, you cannot appeal. Do you understand that?
Yes, sir.
Now, let me also talk to you about some other matters. And I need to ask you some additional questions. Some of these are questions I am required by law to ask. So let's begin with those. First, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
Snide.
My next question asks, do you consider yourself presently, that is at this time, to be mentally competent?
No, sir.
I'm sorry, yes or no?
No, sir.
All right, do you know what mentally competent means?
No, not really.
All right, let's talk about that. Mentally competent, let me ask you this question. We'll get back to that. Have you been able to understand the charges against you?
Oh, yes, sir.
Have you been able to cooperate with your attorney by talking to her about the charges and the facts that sort of make up those charges or surround those charges?
Yes, sir.
Have you been able to hear her advice to you about what the law is and how the law might affect or be affected by these charges
Yes, sir.
and the facts of the case?
Sir.
Mentally competent means you are alert, you are able to understand, you are able to assist your lawyer, that you know what's going on in everything that we're doing. Do you think you are able to do those things?
Yes, sir.
Ms. Brooks, having conferred with your client, do you believe your client is mentally competent?
Yes, Your Honor, I do.
I accept that representation. Just observing and talking to Mr. Wesley, both today and in person, when we've had in-person hearings before, I also agree that Mr. Wesley is mentally competent, knows what he's doing, knows what he's charged with, is able to assist and cooperate with his attorney, and therefore is mentally competent. Mr. Wesley, my next question asks you, are you satisfied with the legal representation your attorney has provided to you in this matter?
Yes, sir.
And let me tell you why I asked that question, because I want to assure you that I'm not trying to suggest that you wouldn't be or shouldn't be satisfied with your lawyer's help. Instead, I just asked that question so that you would have a chance to tell me if for some reason you were not satisfied, if you thought her work was somehow deficient or legally ineffective. Me asking you that question would give you a chance to tell me if you thought that way. Do you understand that?
Yes, sir.
I would also tell you that since I give you the chance to tell me if there's a problem with the lawyer's work, that effectively means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. Now is the time to tell me that so I could get that problem, if it existed, fixed or eliminated. And do you understand all of that?
Yes, sir.
And understanding all of that, are you still telling me you're satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
And let's go further in this plea discussion. The law says I must be satisfied that your decision to plead guilty is your decision, and that it is entered into, that decision is entered into of your own free and voluntary will. And so let me ask you these questions. Has anybody threatened you or forced you or tricked you or in any way tried to make you enter a plea of guilty when you would not otherwise do so?
No, sir.
Has anyone promised that you would get some benefit or something of value just to get you to plead guilty when you would not otherwise do so?
No, sir.
Are you telling me then that you're pleading guilty to these charges because the truth is you are guilty of these charges, and that's the only reason you would plead guilty to such a charge?
Yes, sir.
I believe those are all the questions I have at this moment. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection, Your Honor.
Mr. Wesley, let me talk to you about the stipulation that Mr. Smith from the District Attorney's Office has just offered. And in doing so, let me mention a couple of other aspects of the law that seem to fit right here. First, I tell you that the state is required to produce some evidence in your case that tends to prove that you're guilty. And they have to do that even though you're pleading guilty. That's a part of our law because it helps to ensure that another right that belongs to you is in fact provided to you. That other right is your right to, the legal expression is to confront the witnesses against you. That means you have the right to require the state to call their witnesses into court, have them sworn in and testify in front of you so you can see them and hear them as they give their testimony. But this stipulation of evidence says you're giving up that right, and thus you're telling the state they don't have to call their witnesses into court at all. Did you realize you were giving up that right to confront the witnesses against you when you signed the stipulation?
Yes, sir.
Now, the stipulation also says that you're giving up your right to remain silent, as well as your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, by signing the stipulation, you are giving evidence against yourself because the stipulation says this is a confession, a judicial confession, meaning made in court. And it admits that all of the material allegations in the indictment are true, that you committed the offense just like it claims you did in the indictment. Did you realize you were admitting to the offense when you signed the stipulation?
Yes, sir.
Now, in the stipulation, there's another paragraph that says that you are aware that there are court costs in the sum of $290. There's restitution owed in the amount of $180. And there's a reimbursement owed for reimbursement fees to the county, Scurry County, totaling $675. Did you know that was in the stipulation also?
Yes, sir.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rest, Your Honor.
Does the defense, what does defense do?
We rest as well, Your Honor.
State closes.
Defense closes as well.
Mr. Wesley, I'm now again looking at your plea bargain agreement, and I want to go over with you with the plea bargain agreement to make sure we understand it the same way. The plea agreement says that you will plead guilty, as you have been doing. It says that's going to result in a 2-year sentence to state jail, a fine of $1,500, court costs totaling $290, reimbursement fees totaling $675. But the plea agreement also says that you will be granted probation for a period of 3 years. And that means provided you follow all the rules of probation. And further, that probation will be a deferred adjudication probation. The plea agreement says you're going to waive your right to appeal, and I have already discussed that with you. And it says one of the terms of probation will be that you participate in what's called the TAP program, Treatment Alternatives to Incarceration program, which is an assessment, treatment, and counseling program directed by the Community Supervision and Corrections Office, which is the probation office. Now, those are the things that make up the plea agreement as I understand them. Do you have the same understanding about the plea agreement?
Yes, sir.
Are you asking me to approve this plea agreement?
Yes, sir.
Ms. Brooks, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor, you have.
And Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, you have, Your Honor.
All right, Mr. Wesley, I announce that I will accept and follow your plea agreement. And so I announce that in cause number 10,837, in the case styled State of Texas versus Alonzo Jovan Wesley, that based upon the plea of guilty and based upon the evidence stipulated to by Mr. Wesley, I find that Mr. Wesley is, well, I find that the evidence, let me pause. I just remembered I left something out. I'm supposed to tell you, Mr. Wesley, and so let me do so, that there are benefits and there are detriments to a deferred adjudication probation. I'm confident your attorney has done that already, but the law says I will do it too. There are benefits. The biggest benefit to a deferred adjudication probation is if you follow all of the rules of probation for the 3 years of probation, then you will be off of probation and you will not be convicted of this offense, because in a deferred adjudication probation, the court does not enter a finding of guilt. I might find that it is sufficient to find you guilty, but if I don't enter the finding of guilt and you satisfactorily complete probation, then the finding of guilt will never have been entered, and you can truthfully, accurately, and legally say that you have not been convicted of this offense. That's a benefit. But there are detriments as well. For one, the state can use the fact that you have a deferred adjudication probation for a state jail felony and penalize you by not allowing you to get certain licenses from the state, such as a plumber's license, a lawyer's license, a doctor's license, a nursing license. Certain professional license can be denied to you because of a deferred adjudication probation. And if so, that's a detriment. It's also possible that some employers, private employers, for instance, might find out that you have a deferred adjudication probation for a felony, and they might refuse to give you a job or to give you a promotion. If so, that's a detriment to you. I think they would be wrong in doing that, but that if that happens, certainly that's a detriment. The biggest detriment is if you do not follow all the rules of probation while on a deferred adjudication probation, the state can file a motion to revoke your probation or to ask that the judge go ahead and enter a finding of guilt, as well as to revoke your probation. And if that occurs in the 3 years you're otherwise on probation, then the judge can use the entire sentencing range. So it's not just limited to what your plea agreement is. It could be for any term and any amount of money that the range of penalties allow. Do you understand that there are benefits, but there are also detriments to a deferred adjudication probation?
Yes, sir.
Do you want me to give you a deferred adjudication probation?
Yes, sir.
All right. I do find that based on your plea of guilty and the evidence you stipulated to, that the evidence is sufficient to find you guilty of the charge. But following your plea agreement, I do not enter that finding of guilt at this time, but instead place you on probation for a period of 3 years, provided you follow all the rules. And so let me ask you, do you know what the rules of probation are that you'll have to follow?
A little bit.
Have you had a chance to go over them with your attorney?
Yes, sir.
Can you follow all of these rules?
Yes, sir.
Will you follow all these rules?
Yes, sir.
And I ask it that way because if you cannot or will not follow the rules, then you're probably wasting your time, because you will not likely be allowed to stay on probation if you're out there breaking the rules.
Yes, sir.
And that, all right. Can you read and write the English language?
Yes, sir.
Very good. Then I will cause you to get a copy of the rules of probation and a copy of your judgment so that you can read them at any time and keep yourself familiar with what your rules are. And so I'm not going to read the rules to you since you can read them yourselves, but I am going to mention some of them to you just for emphasis. The first rule I will emphasize is you must follow the rules. You must follow and obey the law. If you're out there breaking the law, you cannot expect to stay on probation. Next, I'm going to order you to stay away from drugs and alcohol in any form and not to go places where drugs and alcohol are sold, served, consumed, or possessed. I do make 3 exceptions, and you can talk to your probation officer about those exceptions, but they are, you can go into a grocery store, you may go into a convenience store, and you can even go into a restaurant, even though those places sell alcohol. You just can't possess the alcohol or consume it or buy it, anything of that nature.
Yes, sir.
All right. While on probation, you'll report to the probation officer here in Snyder, and you'll do so every month before the 5th day of the month, unless you and your probation officer decide that a better date would work for you and the probation office. Where do you live?
Colorado City,
What's the address?
2012,
Hold on.
Chestnut.
2212?
No, sir, 2012,
2012.
Chestnut Street.
And that's in Colorado City, Mitchell County, Texas?
Yes, sir.
Since you live in Mitchell County, you will be required to report to the probation office in Mitchell County in person each month. And then you will also send a written report to the probation office here in Snyder each month. So you have 2 reporting obligations, one in person in Colorado City, and the other one by writing to the probation office here in Snyder after we get started. You will also be ordered to pay a fine, court costs, restitution, and reimbursement fees. As I've already mentioned, they all total $2,645. Do you have the ability to pay all of that in one lump sum payment today, or are you asking permission to pay that out on a monthly basis?
Can I pay it out on a monthly basis?
All right, sir, let me talk to you about that. Do you also understand that I'm going to order you to pay $60 per month as a supervision fee to the probation office?
Yes, sir.
Then how much extra can you pay, or are you asking permission to pay in order to take care of the fine, court cost, restitution, and reimbursement?
Can I do $100?
Let me ask you, are you talking $100 plus 60, or are you asking, is that what you're asking?
Yes, sir.
Do you have the ability to pay that amount of money each month and still take care of your needs and the needs of any dependents that you have?
Yes, sir.
All right, sir. Then I approve that request. I'll make it a term of your condition, a term and condition of your probation, and you'll have to pay the $160 each month. While on probation, you'll observe a curfew. You will not leave your home county for more than 3 days unless you get written permission from your probation officer. You will perform 160 hours of community service restitution, and you can do that here in Snyder, or you can do it in Colorado City, or Mitchell County. Your probation officers there will tell you places that you can do the community service. Your probation officer here will also give you tips about places you can do your community service. Then I will require you to come and see me for a probation performance review on the 15th day of April, 2021. That's a non-adversarial hearing where I check to see how you're doing on probation. I have 2 sessions that day, one at 9:30 and another at 1:30. I'll give you your choice. Which one would you want to come to?
You said there was one at 1:30.
Yes, sir.
Can I do that, please?
Yes, sir. You may, and I'll make that a term of your probation and see you at 1:30 on April 15. Now, these are not all of the rules of probation. There are others, but these are the ones I emphasize because I see people having the most difficulty with these rules. But since there are other rules, let me give you a chance to ask any question you might have about any of the rules. Do you have any questions?
No, sir.
All right. Then that will take care of your plea hearing, and you will be required to go across the street to the adult probation office. Do you know where that is?
Yes, sir.
Mr. Oliver, who does he report to over there?
He will report to Shelley.
All right, you'll see Shelley Duggan. Mr. Oliver, how does his judgment and,
I'm on my way over to pick it up, Judge.
okay, and we'll need to get his fingerprint on the judgment, or
Okay.
his thumbprint. Mr.
If he'll wait over there, I will do that while I'm over there.
All right, Mr. Wesley, Mr. Oliver, the man you see in the screen under the name Chris Oliver, he will be over in just a moment. He will help you put your thumbprint on this judgment, and then he will give you further directions about going to the probation office as soon as we're through. Thank you, sir. You may step away, you may step out of that room and wait for Mr. Oliver in the hall. He'll be here in about 5 minutes or less. Just step outside that door and wait in the hallway. Leave the door open. Ms. Brooks, do you have any other cases this afternoon?
No, Your Honor, may I be excused?
You may. I'm sorry we took so long, but I appreciate you working to help us get it done.
Absolutely. Y'all have a good day.
You
Thank
too.
you.
See ya.
Yeah.
Ms. Fuller, who do you have besides Silva, which we'll do tomorrow?
Thank you, Ben. Miss Gonzalez, I believe, is right there in jury room. I can't really tell because she's far away and it's on the top of her head.
It is.
There she is. Yes. That's the only pretrial I have, Your Honor. And
Okay.
it should be really short.
Ms. Gonzalez, if you would reach up and pull the top of the laptop towards you just barely. Barely a little more. Okay. And since, is there anyone else in that room with you?
No.
If you would, please remove your face covering since you are there by yourself. All right, I call cause number 10,826 for the case style, the state of Texas versus Jane Gutierrez Gonzalez. This case is called for purposes of pretrial. As are all of our proceedings today, this hearing is being conducted by remote video teleconferencing technology and live streamed on the court's YouTube channel to comply with Texas Supreme Court mandates and orders from the Office of Court Administration. For purposes of pretrial, what says the state?
State's ready, Your Honor.
And defense?
We're ready, Your Honor.
And the record will reflect that Jane Gutierrez Gonzalez is also present with us and participating by remote video teleconferencing technology. Let me ask, are there any pretrial matters we need to take up in Ms. Gonzalez's case, or Ms. Gonzalez's case at this time?
Nothing from the state, Judge.
Defense?
Keep forgetting to unmute. The defense doesn't have any pretrial matters for the court to take up.
Are all pretrial matters being taken care of that need to be taken care of?
Yes, sir.
What do we anticipate doing with this case?
Well, Your Honor, at this time, Ms. Gutierrez does not wish to accept the plea offer that the state has made, so.
Okay, and she absolutely does not have to. She does not have to take a plea offer. We are proceeding with jury trials. The limitation on in-person hearings does not apply to jury trials. And therefore, I announce that next Friday afternoon by end of day is the plea cutoff date. This case is a little bit down, not all the way, but a little bit down the jury trial docket. And I do not believe we will reach it because there are cases in front of it that I think will go to trial. But Mrs. Fuller, I know that you are aware of our plea cutoff policy, and therefore I'm not going to worry about trying to explain it again. Mr. Keith has cases that look like they're going to trial. And so if you have any desire to keep up with that, to find out where you stand on the docket, you certainly may confer with him.
Yes, sir, I will. Thank you, Judge.
Then is there anything else that we need to take up in the Jane Gutierrez Gonzalez case at this time?
I have nothing else, Your Honor.
Nothing from the defense, Your Honor.
I need to ask Ms. Gonzalez if she is reporting for bond supervision.
Yes,
Have you paid all of your fees?
not yet. I'm waiting for my stimulus to come in and I will pay it in full then. Well, what I owe, what I'm behind.
The obligation exists and there is nothing that says subject to getting your stimulus check. However, if you get that accomplished, I'm confident that we can work with you to get that accomplished. Otherwise, you do have to get that taken care of to comply with your bond supervision requirements. Do you have any questions? And if you do, you should ask them of your lawyer.
Okay.
And we'll be in recess in your case. You may be excused. Just leave everything there as it is, and someone else will probably be using that computer as well.
Okay.
Thank you.
Thank you, Judge. May I be excused?
Yes, with the understanding we'll do Mr. Silva tomorrow at 3. And if you and your client are ready before then, I'll try to log in before then, and
Okay, do y'all have anything tomorrow before the 3 o'clock?
I have several things, but I hope to be through before 3. In
Okay.
fact, I know I will be. Do you have time to do it earlier?
Well, I have a 9 o'clock with Abra with Judge Hall, which we're just not sure how long that's going to take.
I can't do it in the morning. Absolutely
Well,
cannot.
yeah,
do it.
it's a contested custody, so I mean, it could take 4 hours, maybe 5. So it'll be done by 3, but I'm not sure when it'll be done.
Well, I'll tell you what, if you're done, once you're through and if you want to get started earlier, I should be able to,
Okay,
and you just get in touch with us and we can get started early.
sure. I'd love to do that earlier if possible.
Okay. If possible, we'll be happy to do it earlier.
Thank you.
Sounds
Thank you.
good.
Thank you, Ben.
Bet. See you, Jeannie.
All right, I have Trey next, and then I have the jail. Let's get Trey on here. He may be joining on his iPhone. But he is up here. Have you seen him today, Ben?
I heard him about an hour ago. He was in our office, and I heard him out in the hallway, or out in Jared's part of the office. Since all of his, I think all of his people are in jail, I was wondering if he was going to go over there. There he is.
Maybe it is. There's his box. Trey, are you there? Mr. Keith, are you with us? He's not with us.
He's frozen. There he is.
I'm going to suggest he go in there in front of the laptop. Are you with us, Mr. Keith? We're not hearing you.
Judge, are you talking to me?
Trying to.
Okay. I don't know what the deal is. My laptop was a little slow on the start from time to time, but if you followed that paragraph, then I guess my machine's working now.
Okay, seems to be. And let me bring your client into this meeting, this hearing.
Yeah, it's on. Can you hear us?
Yes, ma'am.
Oh, let's put it up there so you can see.
Good afternoon, Mr. Hull.
Morning.
I used to have a teacher in school who said, I will not be disagreed with. It's afternoon, not morning. All right. Let's get started with your pretrial. I call cause numbers 10,794 and 10,795. Each case being styled the state of Texas versus Tommy Ray Hull. These cases are called for purposes of pretrial. The pretrial hearings are being conducted by remote video teleconferencing technology and being live streamed on the court's YouTube channel in order to comply with Texas Supreme Court mandates, as well as Office of Court Administration mandates and orders. I'll just state for the record, no one is present in the courtroom except myself and the court reporter. Mr. Hall is present with us and is in front of a laptop in what I call the Zoom room at the Law Enforcement Center. And Mr. Keith and Mr. Smith are also with us remotely from, I believe, different parts of the courthouse, but not the courtroom. For purposes of pretrial in these hearings, what says the state
State's ready, Your Honor.
and defense?
Ready, Your Honor.
Do we have any pretrial matters to take up in Mr. Hull's case at this time?
The state does not, Your Honor.
Defense?
Judge, Mr. Hull has asked me to seek a bond reduction. I filed, I got a motion in each case filed, I believe, the end of the month. But I would like to take those up at this time if we may.
All right, I'm looking in the file and I see those. State, are you aware of those?
Yes, sir.
All right. Are you ready to, let me first ask, do we have any other matter, pretrial matter, Mr. Keith?
No, Your Honor.
Okay. Then I will take up the motions for the two different motions for bail reduction. I will take them up together and hear them together. Is that acceptable to the defense?
Yes, Your Honor.
All right, sir. Then you may proceed, Mr. Keith, or your motions, you and your client's motion.
Thank you, Judge. Your Honor, I call Tommy Hull.
Yes, sir.
Mr. Hull, would you raise your right hand and be sworn as a witness?
Yes, sir.
You solemnly swear that the testimony you may give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may lower your hand. Go ahead, Mr. Keith.
Thank you, Your Honor. All right. Tommy, right now, you have a bond set. You just cannot afford to make it. Is that accurate?
Yes, sir.
What is your bond set at currently?
50,000.
And is that 25 in each case, or is it 50 in each case?
I think it's 25 in each case.
All right. And that's the way I read some paperwork. But in any case, assuming that your bond is a total of $50,000, your bail amount, have you tried to make bail at that amount?
Yes, sir. And they want $5 grand up front.
Okay. And is that something that is within your grasp at all?
Yes, sir. Right now it is.
So why does your bond amount need to be reduced?
Because I can't afford the $5 grand.
Okay.
I had it, huh?
Okay. And that's what I need to clarify. Whether you have the resources, either personally or resources that you have access to through family members or friends who are willing to help you. That's what the judge needs to hear about.
Yes, I got some family members that can help, but they can't come up with that kind of money.
Okay. So where we need to get at now is what kind of money is realistic? What types of funds are realistically available to you to help you hire a bondsman?
Probably 2.
So are we asking the judge to lower the bonds to say $10,000 in each case? If the total was 20, is that a bond amount you think you could afford?
20, yes.
All right. And you have every intention of showing up subsequently for hearings and trial, is that right?
Yes, I'm going to show up, yes.
And you were on bond, actually, before you got indicted, right?
Yes, sir. Yes, sir. I was on bond. I was working. I was reporting on bond. I paid my bond off. I mean, I ain't trying to go nowhere. I'm just trying to help my family get on their feet till, you know.
Do you happen to know why you were not able to remain on bond? Did your bond go up after you were indicted, or did your bondsman just withdraw? What happened there?
When I got indicted, Connie told me to turn myself in. That's what I did. I did just like she told me. She told me the bond might stay the same or they would raise it. When they raised it, she wouldn't do nothing for me. And I didn't owe her nothing. She said it was too high.
What was the bond amount? What amount did you make the bail on originally?
She charged me $1,000.
And were you making payments to her?
Yes, sir. I was
Okay,
giving her like 200 every 2 weeks.
all right. So the original amount then clearly was raised at the time you were indicted. And since then, you haven't been able to bond out again, right?
Yes, sir.
Were you charged with or arrested for any new offenses during the time that you were out on bond
No,
release?
sir. No, sir.
And about how long were you out on bond release?
I was out 9 months before they indicted me.
Okay. All right. Let's see, Mr. Hull, is there anything else that I need to ask you about, that the judge needs to hear when he decides whether or not he should set the bonds in your case to a lower amount, say
No, sir.
10,000 apiece?
No, sir.
Okay. All right then, thank you. Pass the witness.
Okay, thank you.
Mr. Hull, I just have a question or two. Now, one of your charges is evading arrest, correct?
Yes, sir.
Wouldn't you agree that if somebody's charged with running away from the police whenever they were required to stop for the police, that might indicate that that person is a flight risk?
I guess, I don't know. I don't.
Judge, those are all the questions I have for the defendant.
Anything else, Mr. Keith?
Oh, no, Your Honor.
All right. Any final summation?
Judge, I think it's certainly the case, what Mr. Smith mentioned. The fact that one of these charges is an evading arrest is certainly a red flag about flight risk. But again, it's just an allegation at this point. In any case, Mr. Hull testified that he was out on release for about 9 months. And when his bondsman told him to turn himself in, he did. I believe, Judge, under the circumstances, given Mr. Hull's, and I didn't take his testimony on this, but I think we can take for granted that Mr. Hull's a longstanding resident of Scurry County. In any case, Judge, I think there is evidence sufficient that would at least warrant a reduction of Mr. Hull's bail amounts. $10,000 in each case should be sufficient. That's all I've got, Judge.
Your Honor, if I may.
Yes.
Judge, both cases are third-degree felonies. Both cases are double enhanced with 2 prior felony convictions of this defendant. Both bonds are set at $25,000. Those are just, for somebody that's facing 25 to 99 or life, $25,000 is a reasonable bond, it seems to me, in each case.
Anything further?
No, Your Honor.
All right. This case is set, one of these cases is set for jury trial this month, beginning Tuesday morning, the 26th of January, 2021. We have attempted to provide Mr. Hull with his right to a jury trial on at least 2 prior occasions, one of which became impossible because an ice storm hit this part of the state, and people could not even travel a few blocks to the trial room. And so that one was canceled. The next one was canceled because of the COVID pandemic, and specifically, I was tested positive for COVID 5 days before trial. Just for the record, I had absolutely no symptoms and never had any symptoms of the virus. I was only tested because the local health authorities wanted to be able to give some assurance to the jury panel that all efforts were being made to provide a safe environment. And so, again, at no fault of Mr. Hull, the case was not able to be tried. This month's jury trial will be the first opportunity we've had since then to conduct the trial. I am going to accept both of the attorneys' representations. I am persuaded at this time by the state's attorney, and I'm going to deny the motion to reduce bond. If something were to happen to this jury trial, I will again take up the defense's motion and reconsider it. But for now, we're set number 1 and going to trial on June 26th. Thank you both. Is there anything else to take up in Mr. Hull's case or cases? Oh, let me ask, which case are we going to go to trial on the 26th?
Judge, I intend to go on the evading arrest case, which is the 10,795.
All right, sir. Let me just announce for the record that the Supreme Court mandates restricting in-person hearings and the Office of Court Administration orders thereon expressly exclude jury trials from their restrictions. Now, there are still restrictions, and this court has complied with all of those restrictions, including getting our plan for holding a jury trial approved by our presiding regional judge, our regional presiding judge. The trial will take place at the Armory. We have had a couple of proceedings there, including one this Monday that tests how we can, whether we can conduct a trial there and provide everybody with a fair trial. I was satisfied that those tests do show that we can provide for the health and safety of our jurors and participants, as well as to provide our participants with a full and fair trial. Therefore, we're in recess and we will go to trial on the 26th of January, barring something that none of us can anticipate. Thank you. We'll be in recess. Thank you, Mr. Hall. You may step back out of the room.
I guess they're going to fetch Billy Rodriguez next.
That's my understanding.
Judge, who did we do before Mr. Hull?
Oh, we did Jane Gutierrez Gonzalez,
Okay,
number 10,826. And all we did was pretrial.
okay,
And they advised that there were no pretrial matters pending at that time, that she still desired to have a jury trial.
Okay.
She reported that she had been reporting for bond supervision, but had not paid her payments. She was waiting till she got her stimulus check.
okay.
I didn't ask her which stimulus check, but that was the report.
All right, thank you, Judge.
Good afternoon, Mr. Rodriguez.
Yes.
We're waiting for, there is your attorney. Start to say we're waiting for your attorney, and then we'll get going. I call cause numbers 10,734 and 10,735. Each case style, the state of Texas versus Billy Rodriguez. These cases are called for purposes of pretrial hearings. The cases are being heard, or the hearing is being conducted by remote video technology, teleconferencing technology using the Zoom protocol. It's also being live streamed on the court's YouTube channel in order to comply with Supreme Court mandates, Texas Supreme Court mandates, and mandates and orders out of the Office of Court Administration regarding in-person hearings. All parties are participating remotely. No one but myself and the court reporter are present in the courtroom, and he is social distance from me. With those preliminary remarks, for purposes of pretrial, what says the state
Ready, Your Honor.
and defense?
Ready, Your Honor.
Do we have any pretrial matters to take up in Mr. Rodriguez's case at this time?
The state does not, Your Honor.
Defense?
And Judge, the defense does not have anything to take up at this time either.
All right, these cases are set on the trial docket for January 26, 2021. Plea cutoff is Friday, end of day Friday, January 15. And I've heard some suggestion that effectively means the plea would have to be accomplished by end of day January 14. It's not any aspect of mine, but I've heard that may possibly be a practical result or requirement. If we were to go to trial on Mr. Rodriguez's case or cases, which one would we try first? Or both of them at the same time, whatever I'm asking.
If we tried them separately, the state would prefer to try the aggravated sexual assault case first, but it's possible we would try the cases together, or at least seek to.
Okay.
As a practical matter, that would probably be, Ben, I'm not looking at the indictment. Maybe I should actually take a look at it, but were these cases enhanced with the prior 21-0?
Yes.
So the consequence of conviction is life.
Yes.
Okay.
And is that true on either case?
No, I don't think that's true on the 10,735 case. It is enhanced, but I don't think it's an auto life. I think that's just a standard third degree enhanced to a second degree.
That, I'm looking at the indictment, that appears to be correct. Okay. All right. Is there anything else then that we need to take up in either of Mr. Rodriguez's cases at this time?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right. Thank you,
Judge,
Mr. Rodriguez. Pardon?
would you permit me while we're here to take about 15 seconds and advise, not as legal advice, but I just want to let Mr. Rodriguez know that the expectation that his case will actually be reached is low, since another of my clients is much more likely to be tried on that date. That's all I wanted to convey to Mr. Rodriguez on this occasion, Judge.
If I were a humorous person, I would say, no, I'm not going to allow that. Do you understand, Mr. Rodriguez? We probably will not get to your case this month for trial. It will probably be February before we can get your case to a trial. Do you understand that?
Yes.
Okay. There is an outside chance that you could go to trial this month, but in all likelihood, it will be February before your case will go to trial.
Okay.
All right, sir. Then we'll be in recess. Thank you, sir. You may be excused. Tell the officer behind you that you're through.
Judge, just to give you a little information,
That's all I get.
Jane Gonzalez Gutierrez is assigned to me for bond supervision. She has not darkened our door since October.
Yeah, right there, okay?
Please tell me that again, Mr. Oliver.
Ms. Gutierrez Gonzalez has not reported for bond supervision since October.
Did you hear that, State's Attorney?
I did. Thank you.
I think a phone conversation or a discussion tomorrow when we visit with Ms. Fuller and her other client might be in order.
Yeah.
Mr. Oliver, are you going to be a part of the plea tomorrow afternoon? Plea
Yes, sir.
hearing? Okay. Then I may call upon you for to share that information with Mrs. Fuller at that time.
Certainly.
All right.
Take it off.
Massengill, please remove your hat. You're in the courtroom.
I apologize, Judge. I didn't think to tell him.
All right, we'll hold it against Mr. Keith
Thank you.
instead, all right? I call cause number 10,769 for the case style, the state of Texas versus Travis Glenn Massengill. This is a pretrial hearing in Mr. Massengill's case. The hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. The hearing is also being live streamed on the court's YouTube channel to provide public access to the courts.
Calling me Mr. Messenger?
I'm sorry, Mr. Ramish, we're a little bit ahead of time. Who is that with you? Mr. Ramish?
Mr. Call? One of my MTRs, Judge.
Oh. I'm fine with him remaining there. But Mr. Koff, we're not hearing your case yet. We'll get to you very shortly. You may remain there and observe the other proceedings. And we'll get to your case very shortly.
Okay, stay.
You can stay there. All right, I was talking about Mr. Massengill's case and the fact that it's being conducted remotely in order to comply with Supreme Court mandates. And being live streamed to provide access to the public. This hearing is a pretrial hearing in Mr. Massengill's case for purposes of pretrial. What says the state?
Ready, Your Honor.
And defense?
We are ready, Your Honor, and if you've got time this afternoon, we have an agreement with the state. Mr. Massengill and I would, since he's here in the building, we would review the paperwork and have it ready to present to you sometime this afternoon.
All right. I think that is possible, and I will be happy to make every effort to make that occur if we can. Do we have anything else in Mr. Massengill's case then?
I don't, Your Honor.
No, sir.
All right. Then we'll be in recess in Mr. Massengill's case and proceed to another pretrial matter for Mr. Keith. And you may wait in the hall, Mr. Massengill, until Mr. Keith visits with you further.
Thank you.
Thank you, sir. All right, I call cause number 10,629 for the case styled the State of Texas versus Billy Ray Koff Jr. This is a pretrial hearing in Mr. Koff's motion to revoke probation case. As I've said, in each of these cases, this is a remote video teleconferencing technology case using Zoom protocol. That is, we're hearing this case remotely and not in person. The case is also being live streamed on the court's YouTube channel in order to provide access to the courts, to the public. For purposes of pretrial in this matter, what says the state?
State's ready, Your Honor.
And defense?
Ready for pretrial, Your Honor.
Do we have any pretrial matters to take up in Mr. Koff's case at this time?
The state does not, Your Honor, other than to request a setting.
All right, I'll get back to that in just a moment. Does the defense have anything to take up?
No, Your Honor.
Are we talking about a contested proceeding that has some bearing on when I can schedule it?
Judge, I don't know. Actually, this is a case that Mr. Keith and I haven't had a chance to discuss. And so I haven't even been able to make him a plea offer.
Before I leave here today, Judge, I'll visit with Ben about what the state thinks they require. And I'll see Mr. Kolf at the jail before I go back to Sweetwater. Whether that's at 4 o'clock or 7 o'clock tonight, I'll do that.
Then would it create any, would the defense have any objections to me suggesting that we not set a hearing date at the moment, but instead allow defense to confer with state and with the client? And then if we need to have a hearing, contested or not contested, then the attorneys could get back with me and we would set a date fitting the scheduling that the attorneys need for their schedules.
That, the defense is fine with that, Judge.
All right.
And I am too, Judge.
All right. Then is there anything else we should take up while Mr. Koff is with us?
I have nothing else, Your Honor.
No, Your Honor, thank you.
Yes, sir. Mr. Koff.
Am I allowed to talk?
You are allowed to talk.
Can I ask you a question, sir, Your Honor?
You may, but let me remind you that you have an attorney, and usually it's more advantageous to ask your questions of your attorney so he can filter them.
And I will be seeing you this afternoon before I go back to Sweetwater, Billy. I got appointed on the 8th of last month, but 10 days later, I got sick with COVID and I was out of commission for 2 weeks. I'm barely back in service now, but
I'm glad you're healthy.
thank you. I just want you to know that I haven't been ignoring you, and I will address whatever we need to address when I see you over at the jail through the glass, but this afternoon, okay?
If it's okay with my attorney, while I have probation, Mr. District Attorney and the judge all together in one spot, can I say something that I think is important for my current situation?
Keith?
It's your call, Billy. My preference is no, but it's your case, and in fact, the important people are here right now. If you feel that it's that necessary, then be brief, but be to the point.
My living arrangements have changed substantially. Since I've been put on probation, my financial situation has been a major issue about not being able to make my payment every month. I recently moved, Lubbock picked me up November 10th. I moved into my apartment, my new apartment, November 7th.
Billy,
Yeah.
these are defensive issues and they are factual. They go to mitigation and they go to the allegations in the motion to revoke. And so for that reason, I get that they're important to you, but we don't need to, it will not be useful for you to continue with those defensive points, okay? I'll visit with you this afternoon.
And that's what it says in the MTR. That's one of the major reasons why the state is trying to revoke me is money issues, and my money situation has completely changed for the better.
Absolutely. So you'll make that clear to me this afternoon. And when I get back with Mr. Smith next week, I will explain to him in detail everything you convey to me, okay?
So there's no chance of me going home until the next time?
I don't know what there's a chance of, but today, absolutely none.
So I will see you, Mr. Keith, later today?
Yes, sir.
Okay.
That's all we have, Judge.
All right. Thank
I
you.
can go?
Yes, you may. Thank you, sir.
Thank you guys for your time. I appreciate it.
Yes, sir. Do you have anything else, Mr. Keith?
Judge, I am also set in it's a similar situation. A girl I haven't seen in person, Lachelle Tondra, but she's got 2 MTRs pending.
Yes.
I believe. Okay.
What about it? I'm sorry. I'm not following you.
Oh, you asked me if I had anything else. I think that's what I was trying to respond to. Perhaps I misunderstood your question.
No, I have her files also,
Okay.
but is she incarcerated? I think she is. And I
Yes.
guess the sheriff's office went to get her.
Okay.
And by went to get her, I mean bring her into the Zoom room. There she is.
Hi.
Good afternoon. Are you Miss Tondra?
Yes, sir. Tondra, yes, sir.
Tondri, I'm sorry. All right, I call cause numbers 9,880 and 9,881. Each case is styled the State of Texas versus Lachelle Lynn Tondre. These cases are called for purposes of a pretrial hearing. These hearings are being conducted by remote video teleconferencing technology using the Zoom protocol. This is done to comply with Texas Supreme Court mandates and orders issued out of the Office of Court Administration. That explains why you are in the Law Enforcement Center, Ms. Tondre, and I am in the courtroom. Your attorney is in another location, but appearing before us on his computer, as well as the district attorney and the probation office.
Yes, sir.
With all of that, for purposes of pretrial in these two matters, what says the state?
State's ready, Your Honor.
And the defense?
Ready, Your Honor.
Do we have any pretrial matters to take up in Ms. Tondra's cases at this time?
The state does not, Your Honor.
Am I able to speak to my lawyer privately before I do anything? Oh, sorry.
Oh.
I haven't spoken to my lawyer at all.
And that is accurate, Judge. Similar to the last case we had, I was appointed to her second week of December, shortly before I got sick. And anyway, you know, I'm sorry that that's the case, but
Just
Lachelle,
a couple minutes if that's possible.
what?
I just need a couple minutes to speak to you if possible.
Michelle, I'm going to come see you at the jail in person this afternoon. We're not going to resolve your case at this hearing. The purpose of this hearing is just for the court and for the DA and me and the probation office to get on the same page, sort of status-wise, okay?
Okay.
But I'm better. I'm going to go see you at the jail before I drive back to Sweetwater this evening.
I appreciate it.
So we're going to cover all these allegations and we'll cover what your goals are, okay?
Yes, sir.
And then your case will be set for another appearance, whether we're going to make an agreement or whether we're going to have to ask the judge to decide, okay?
Yes, sir. I appreciate it.
Okay. That's not a formal announcement to the court, and I apologize for being able to listen to counsel speak to his client and vice versa. But it sounds like that the defense needs to consult with one another the attorney and the client.
I mean, I can put in a plea still. I'm absolutely guilty. I would still, I'm sorry, Trey, if I'm guilty, I would still put it in. I'm guilty.
Just be quiet.
Wait till you have a chance to talk to your lawyer by yourself
Okay.
and not in front of everybody else and not on the record. That's what any lawyer would tell you, I'm sure. So I gather that the main thrust of this pretrial hearing is the parties, the defense need to consult among defense, and then counsel for defense needs to consult with the state's attorney even before we do anything further. Is that a fair statement?
Yes, sir.
All right. And while Ms. Tondre is able to listen to our conversation, let me just advise that after Ms. Tondre has a chance to talk to Mr. Keith and consult further with him, I am always available for y'all to get back with me and the state's attorney to schedule things. And so if we need to schedule things for another pretrial hearing or for a disposition or an actual trial, which would be before the court, then we can do that. In essence, continuing this case this afternoon doesn't mean it's continued for a long time. It just means
Okay.
it's continued until y'all have a chance to confer.
Okay, that makes me feel better. Thank you.
All right. With that, and hearing nothing further needing to be taken up at this time, we will recess Ms. Tandre's cases until either I hear back from the attorneys or we schedule our next pretrial hearing. All right, we're in recess. Thank you. Thank you, Ms. Tandre. You may be excused.
Thank you.
So Judge, I believe that's all of mine pretrials anyhow.
Okay.
Right, we have Mr. Massengill's papers ready.
I'll come down and get them. Thank you, sir.
Okay.
Judge,
Yes.
Sam is going to be appearing virtually after all.
Okay. Are all of his cases incarcerated?
He just has the one, which is Sebastian Gonzalez, like one guy from this morning.
There you go, Jared.
Oh, yes.
We actually had the pro se defendant set next, but
Looks like he's coming in. Yeah, that's Mr. Oh, I forgot his name. That's Lozoya. Here's let's proceed with Mr. Lozoya. I call for purposes of pretrial cause numbers 10,839 and 10,840. Each case is styled the State of Texas versus Frankie Lozoya Jr. These are pretrial hearings in these two cases that are being conducted by remote video teleconferencing technology in order to comply with Texas Supreme Court mandates and orders, as well as mandates and orders from the Office of Court Administration about not conducting hearings in person. Therefore, this hearing is not in person. I'm the only one in the courtroom where I conduct these hearings. No one else but my court reporter, I mean the court's official court reporter. No one else is present in the courtroom. These hearings are also being live streamed on the court's YouTube channel in order to comply with the Supreme Court mandates and the constitutional obligations to provide access to the public to the courts. With those pronouncements, for purposes of pretrial, what says the state?
Ready, Your Honor.
Mr. Lozoya, are you Frankie Lozoya Jr.?
Yes, sir.
Could you scoot yourself a little bit closer to the computer? Thank you, sir. We can hear you better when you're that much closer.
Okay.
Mr. Lozoya, at our last pretrial hearing, I think one of the questions to you was, were you in the process of employing an attorney? And at that time, my recollection is that you were trying to do that. Is that correct?
Yes, sir.
Would you give me an update on where you are in that process?
Right now, they're still in the process of doing that. They're trying to come up with the money for it.
Is it still your request that you be given that opportunity, a little extra time to get that process completed?
Yes.
Do you have any other request that I could take up or consider at this time?
Could I get a court-appointed lawyer to see what I can do first, and then if I need till they can get a hired one?
I almost think we had this conversation last time also, and I hope my answer is the same. It should always be the same. And the answer is yes. If you apply for a court-appointed attorney, and if you are eligible and entitled to a court-appointed attorney, I will appoint an attorney to represent you. And further, you will always have the right to hire your own attorney, even if that occurs after you have a court-appointed attorney.
Okay.
Did that answer your question?
Yes, sir.
So my next question to you is, do you want to apply for a court-appointed attorney?
Yes.
Have you filled out the request form? It's called an affidavit of indigence and request for court-appointed attorney. Have you filled that out?
No, sir.
All right. There are forms to do that there in the jail. I will ask someone in the jail to give you that paper, that document, and then I will send somebody by tomorrow morning to visit with you to make sure that it's filled out correctly so nothing is left out, or so I can properly consider it. If you are indigent, I will appoint an attorney to represent you. And if you have it filled out by tomorrow, or if you fill it out tomorrow when that person comes by to visit with you. And by the way, that person is Terry Hanshoe. Mr. Hanshoe is a notary, and Mr. Hanshoe is the official court reporter. And he assists us in helping people make sure they filled it out right. He doesn't do it for you. He just helps to make sure that there's nothing left out that needs to be in there, that sort of thing. If you do that, if that's what you still want to do, and you do that, I will look at it by tomorrow and make a decision by tomorrow afternoon. If you're entitled to a court-appointed attorney, I will appoint one, and I will tell you who it is. If you're not entitled to a court-appointed attorney, I will also tell you that as well, but I will give you a decision tomorrow.
Okay, thank you.
Is there anything else that you have, or any other question you have?
No, sir.
Just to your left behind you is Mr. Ramish. I think he has that form in his hand. If so, Mr. Ramish, would you hand it to him? All right. You can spend some time this afternoon and this evening filling that out. Or if you want to wait until in the morning when Mr. Hanshoe comes by, either way, he will assist you in making sure you fill everything in.
Okay.
Okay, sir. Then we'll be through for this afternoon, we're in recess. Thank you.
Thank you.
You may be excused. I lost my, I think there it is. I think Sam is next. Ms. Coordinator, who does Sam have? Does he only have MTR cases?
Yes, sir. Sebastian Gonzalez.
Okay, let's see if I can get the jail there. I think this Galaxy S8 is Sam. Surely that's what the S stands for. You may be seated.
Yes, sir. How are you, Your Honor?
Hello.
Mr. DA, everybody.
Judge,
Yes.
do you want me to ask the jail to get Sebastian Gonzalez instead?
Yes, let's do that since I have Mr. Darnell there. Mr. Luna, if you'll allow me, let me take one other case out of order, and then I'll get back to you in just a moment.
Yes, sir.
Thank you.
Yes, sir.
Mr. Amish, we're looking for Sebastian Gonzalez. Good afternoon, Mr. Darnell. You're muted, which is my favorite form of visiting with you. Can you unmute yourself?
There we go.
There you go. I'm always afraid to ask an attorney to do something to himself. But I was going to tell you that we had an arraignment this morning with Mr. Gonzalez on a newly indicted case. Here we are. Mr. Gonzalez was indicted or was arraigned this morning on a charge of unlawful possession of a firearm by a felon. I think that was a new indictment. Is that right, Mr. Smith?
That's right, Your Honor.
Okay. And it went, I think it was not remarkable. That's the medical term as I understand it, meaning nothing took place.
Yes, sir.
Of any consequence, anyway. So let's do a pretrial hearing on Mr. Gonzalez's motion to revoke case. And so I call cause number 10,804 for the case styled the State of Texas versus Sebastian Gonzalez. Let me announce that this pretrial hearing is being conducted using remote video teleconferencing technology using the Zoom protocol. This hearing is also being live streamed on the court's YouTube channel to provide the public with access to court proceeding. All of this is done either to comply with Supreme Court mandates and orders, as well as mandates and orders out of the Office of Court Administration, as well as to provide public access, satisfying the constitutional obligation to allow the public to have access to the courts. I do not believe that's what that constitutional provision actually means, but we do not mind providing that type of access. And so it is being provided. With those pronouncements being made for purposes of pretrial in the motion to revoke case, what says the state?
Ready, Your Honor.
And the defense?
Ready, Your Honor.
The record will reflect that Mr. Gonzalez is present with us this afternoon as well. Do we have any pretrial matters to take up in Mr. Gonzalez's case at this time? The motion to revoke the probation case.
The state is not, Your Honor. Mr. Darnall and I discussed Mr. Gonzalez's cases just briefly earlier this afternoon. I made him aware he had the new indictment, and I made Mr. Darnall aware that we'd be preparing discovery soon and forwarding that to him, along with, I anticipate, an offer that will resolve both, or that could possibly resolve both cases.
All right.
That is our understanding, Your Honor.
With that particular announcement, I don't want to get ahead of myself or either one of you, but do I understand us to be saying that we don't have anything that we need to take care of this afternoon? Instead, y'all would like the opportunity to look at the discovery and discuss the various offers from the state?
Yes, sir.
Yes, sir.
then being a little more formal, does the defense have any matter that I need to take up this afternoon?
No further matters, Your Honor. We would just simply ask for a 30-day reset and take it up on the February 4th docket.
All right, that's acceptable to the court. Let me tell you also that if you were able to reach some resolution that could benefit from hearing even before then, I can make myself, the court will make itself available. We'll just have to find scheduling times that fit everybody's schedule, including ours. All right, with that, I thank you all for participating, and we will be in recess.
May I be excused, Your Honor?
You may. Thank
Thank
you,
you.
Mr. Gonzalez. You may be excused as well.
Thank you.
I think, Sam, how are you doing?
All I need to do is hit the button and I'm leaving.
No, I meant, how are you doing? Are you doing okay?
Yes, sir. Things are going well here. Everybody's healthy, and courts are adjusting.
Yes, sir. Try some better than others. Luna, we're ready for Luna.
The understatement of the century. You will have a blessed week, and we'll be hollering at you soon.
Thank you, sir.
Thank you.
Yourself. Bye. I think we just have two cases left, Luna and Sneed.
Yes, sir.
And then we can take up that plea later.
Okay.
Come on in, Mr. Luna. Thank you, sir. Do you mind scooting your chair just a little closer? There you go. That's fine. And I thank you for your patience and waiting on us.
Thank you.
The next call for purposes of pretrial in a motion to revoke case, cause number 10,705, the case style, the state of Texas versus J. Waylon Luna. This pretrial hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. The proceeding is also being live streamed on the court's YouTube channel to provide public access to the courts. All of this to comply with Texas Supreme Court mandates and orders, as well as those of the Office of Court Administration. That said, do we have, is the state ready to proceed?
State's ready, Judge.
Mr. Luna, are you ready to proceed?
Yes, Your Honor, I am.
Let me address the very first thing that comes to my mind without even asking the state if they have anything, and that is, what is your representation status? Are you represented by an attorney at this time?
No, sir. My last attorney I had, no, sir, I'm not right now at the moment.
Who was the last attorney you had?
Edward Bartolome at San Antonio, Texas. Mr. Bartolome?
Yes, yes, sir. Are you planning to employ your own attorney in this case?
No, sir, I'm not.
Why not?
Well, Your Honor, to be honest with you, I'm pretty much, I don't see any, I just see punishment coming, sir, so I'm gonna own up to my actions, sir.
I'm not trying to get you to admit anything, so be careful.
Yes, sir.
Are you telling me that you do not have the money to hire an attorney at this time?
No, sir, I don't.
And are you then going to ask for a court-appointed attorney?
If the court allow it, sir, yes, I will.
Well, you can ask for it. The law allows that, no matter what. Here's what I suggest that you do. I see Mr. Ramish is still in the room. He will get to you a form asking for a court-appointed attorney. And then tomorrow morning, the court reporter, Mr. Hanshoe, will come to the jail and assist you in making sure that you fill out the form so that all the information that's needed is put in there. And then I will review it and I will tell you by tomorrow afternoon if you're entitled to an attorney. If so, I will appoint an attorney for you and I'll tell you who that is.
Yes, sir. Thank you, Your Honor.
All right. Do you have, well, let me ask Mr. Smith, is there anything else, Mr. Smith, we ought to take up other than first addressing that attorney issue?
No, the state has nothing else, Your Honor.
All right, then, Mr. Luna, do you have any other question?
No, sir. Just letting the court know I'm back on my medication, so I'm
All right.
mentally competent, sir, to
Well,
proceed.
good for you. I think that's good for you. I mean it that way.
Yes, sir. Thank you, Your Honor.
Then we will be in recess. Mr. Ramish will give you that form, and Mr. Hanshu, you can work on it this evening if you want to. It doesn't take that long. But if you want to wait until in the morning till Mr. Hanshu comes by, he's going to come by and visit with you about it anyway. He's also a notary public, and so he can swear you to the answers, which is required. And then I won't be able to review it until tomorrow anyway, but we will look at it tomorrow and give you an answer then.
Yes, sir. Thank you, Your Honor.
Thank you. You may be excused.
Yes, sir.
Judge, I have Ms. Mead's form. She's already filled one out and it was hanging on the board. It hadn't got to you yet.
Okay. I know she's entitled to an attorney. But let me talk to her.
Hello.
Hello.
How are y'all doing?
We're doing good.
Hi, Chris.
All right, let's get started. I call cause number 10,261. The case is styled the state of Texas versus Tiffany Lachey Sneed. This is a pretrial hearing in the motion to revoke probation case of Ms. Sneed. Well, let me also announce that this pretrial hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. This hearing is also being live streamed on the court's YouTube channel in order to provide access to the public. All of this is being done to satisfy Texas Supreme Court mandates and orders, as well as mandates and orders from the Office of Court Administration. With that, for purposes of pretrial, what says the state?
Ready, Your Honor.
And Ms. Sneed, are you ready to proceed?
Yes, sir.
Let's address the very first thing that I think should be addressed since you're here by yourself, and that is representation. As you were, just before you came into the room, there at the Law Enforcement Center in our Zoom room, Mr. Ramish told me that you had filled out a request for court-appointed attorney. It just has not been presented to me yet. Is
Yes,
that
sir.
correct?
Yes, sir.
I already know because of other cases that you qualify for a court-appointed attorney.
Yes, sir.
And so I'm looking to see who we last used as your attorney, or who you last used as your attorney. Of quite frankly, it looks like Mr. Scott was your attorney the last time you were in court on this case.
Yes.
Is that correct?
Yes, sir. I thought it was I thought it was Smith.
You thought what?
That was a guy named, last name is Smith?
No, Smith is the district attorney.
Okay, okay, it was Sky. Okay, I'm sorry.
That's all right. But part of the problem is, yes, Mr. Scott was your attorney. Part of the problem is that Mr. Scott is deceased.
Oh, sorry.
He passed away. Since you were placed on probation in this case. It appears to me that the next attorney, let me see if I did anything. Ms. Court Coordinator, it appears to me that Mr. Darnell is the next on the rotation list.
Sir.
Am I getting that correct?
Yes, sir.
Okay. Thank you. Ms. Sneed, the next attorney on our rotation is an attorney by the name of Sam Darnell.
Yes, sir.
Have you ever had any representation by Mr. Darnell?
No, sir.
Have you ever been in a case when he was on a side opposite of you?
No, sir.
All right, I'm going to go ahead and order that Mr. Darnell be appointed to represent you.
Yes, sir.
We will notify him today, and then he will be in contact with you. He will first send you a letter, and then he may give you a call to talk to you on the jail phone.
And if excuse me, Judge, but if I didn't want a lawyer, what would be my other options? Like to go ahead and get this done? Or I have to go with the court-appointed lawyer since I already filled out the paper?
No, that's not the reason you would have to. First, you can always hire your own lawyer. That's first.
Yes, sir.
Secondly, if you're entitled to a court-appointed attorney, and you are,
Yes,
I will
sir.
appoint one to represent you. I also must tell you, you have the right to represent yourself.
Yes, sir.
But I also must tell you, that's not a very good option. It could cause you to have lots of other problems because you're not an attorney. You're
Yes,
a
sir.
very intelligent woman. I've had you in court, and quite frankly, you know, I've known you for many of your years. And so that's not a very wise decision.
Okay.
We will get the process started very quickly, and you can always hire your own attorney.
No, I'll accept the court-appointed. Thank you.
Okay. Okay. Is there anything else that you might have a question about this afternoon?
No, sir.
Mr.
I'd like to just apologize for not following by the rules of probation because I know better.
Okay. Mr. Smith, is there anything else the state would like to be considered at this hearing?
Not today, Your Honor.
All right. Very good. Thank you, Ms. Sneed. We
Thank
will
you.
get in touch with Mr. Darnell as soon as possible, and he should get in touch with you very soon.
Okay, y'all have a good day.
Thank you. You too. I believe that concludes our pretrial hearings. I think Mr. Keith and Mr. Massengill are working on plea papers, but I'm not sure what their status is. Mr. Ramus, you got anything else?
No, sir, that should be the last one, and I'll be en route up there to your location.
Thank you very much. I appreciate it. See you shortly. I'm going to remove the jail from this. Let's see.
I don't know if he's paid it yet. It was ordered to be paid in the paperwork. Yeah.
Hey, Ben,
Hey, yes.
I've got a different number on Travis Massengill's explanation of terms and conditions than I show he's been indicted.
Okay, hang on.
I had,
Filed an information
okay,
just this afternoon, so we've got a new explanation.
okay. It's not in the system yet then. Okay.
Yeah, there you go.
All righty. I was just looking up to pull up his case and I thought, man, that doesn't match.
Right. Yeah. I've got the new explanation in my hand right here. So
All right.
whenever you come over to get the rest of it, we'll have this one.
Sounds good. Yeah, I'll come over as soon as we finish the plea.
Alrighty.
Okay, John, it should be in there. Either chicken or beef or pork or. How about peanut butter and jelly? Bye. Does it not have the right number on it?
No, you did. Far enough. I think the paper he had was an old one or something.
I just sent it.
It matches. See.
I mean, I like just. Hey, are nothing there? That you, does it not have it right? You have the, okay, so you have the information number, correct? Which one? Okay. What, what did you need? Yes. And I emailed you a copy of. You want a copy of the offense report, or, I'm sorry, I got a little distracted there. Okay, right. The information, the indictment information is a little different, yes. Yeah, but the offense report is the same. Okay. All right, bye. Dawn just ran out the door, so I totally got distracted.
Yeah. Who called him? Do you know?
He went to the courtroom on the 4th floor.
Can't tell anything's going on by Zoom here. I don't know who would be up there other than Massengill.
The guy we pled earlier to probation,
Yeah.
he came over, started filling out his paperwork, and then disappeared.
Oh boy.
He's been gone about an hour now.
Is Juan up there?
I don't know. Kayla just went into the courtroom. She didn't act like anything was going on.
Don't y'all have access to all the cameras in the courthouse?
I do, but there's not one in the courtroom.
Oh, that's right. Well, there is, the judge has access to.
sure I see Juan's hat at the door though.
I don't know. John just ran out of here to go up to the courtroom. I don't know who said come up here.
Yeah.
I heard him pick up the phone and said, I'm coming right up there. And then he scurried up there.
Maybe Trey had a question. But you think Trey would ask you?
Nah.
I'll do a little snooping. Just a quick question. Is there anything going on out in the hallway? John just ran up the stairs and it was a little odd.
It's at the courtroom.
Yeah. Okay. We thought maybe something was going on and like somebody was out of control or something weird was going on. Okay.
Not asking Gil because he just walked in from the back.
Yeah. Okay.
Who knows?
All right, good.
Chris is talking to somebody.
All right, bye. Lena says she hasn't heard any raised voices or anything. All she hears is the computers in the conference room.
I don't know.
Maybe Publishers Clearinghouse was looking for him and they were on the 4th floor.
They're gonna share it.
Well, let's all go.
$5,000 a week for a life.
For life. You know, and then they say, and then you can designate somebody else to receive $5,000 a week for their life.
Yeah.
Now,
would you be in Dutch with everybody else if you named one person?
well, think about this. What occurs to me, yeah, that's certainly true. But think about if you named your grandson who's a 3-year-old toddler, you might just ruin that kid's life. I mean, seriously.
$5,000 a week for life. Yeah.
That better be a very well-parented, well-grounded person to grow up and be normal.
Name your spouse. That way you double your money.
There you go.
Or that might just give them the incentive to leave. Who knows?
What'd you say, Jared?
Bridget Davis
What about her?
just carried her out in cuffs.
Oh,
She was just in here. I just notarized her thing.
I wonder if she had a warrant or something.
What happened? What happened?
Evidently, the girl who was
Bridget
up
Davis?
there.
Bridget Davis?
Yes. Evidently, she got a little irate. I didn't have the radio on, but evidently Juan called for some assistance. And Brian called me, saw me up there. So she's a little upset. She doesn't know if she's going to get a bond or not. And evidently, she got a little heated, I guess.
Did we have a case? Who is she?
Bridget Davis.
I know. Remind me. That name sounds familiar.
She has the MTR warrant.
She has what?
MTR warrant.
Oh, an MTR. Okay.
She was applying for a court-appointed attorney.
She's on deferred. And
Uh-huh.
she was wanting to know if she was going to get a bond. And
But she hadn't been arrested on her M-tag yet.
No.
Ah.
So she says it's a motion to, she says, or one saying it's a motion to revoke. I told her if it was a motion to adjudicate, she could possibly get a bond on adjudication, correct?
Yeah.
But if it's a revocation.
It's an MTAG.
Anyway, she's outside smoking a cigarette.
He needs to pick her up and take her somewhere.
Yeah, she hadn't been served on her warrant, and I guess she was up here trying to get a court-appointed lawyer and was asking if she was going to be able to make a bond, and she got upset and mad. And I think that's why John was called.
Yeah.
She's calmed down now. Apparently she's smoking a cigarette outside.
If she's smart, she'd leave.
Well, I guess she's got to go to jail and get processed on her M-tag and see if we can make a bond. Any of the folks that we dealt with today on motions or that we haven't already talked about, Chris? You and me?
I don't think so.
I think most of them are Shelley's. that I need to resolve.
Michelle's gonna try to poor pitiful me her way out of anything.
Yeah.
I got a call while we were on Zoom a while ago, and somebody not related to her but associated with her from San Antonio area is calling, wanting to know how much she owes to pay off her case.
Yeah.
I sent Trey a message on Zoom and said, I just got a call. I'm not going to give them any information. I'm going to refer them to you. If you want me to give them information, I'll give it to you and you can give it to them.
Yeah.
But I'm not going to talk to all her friends about her case. Not once she's got an attorney.
That's not helpful. What'd you say, Jared?
I was just wondering on those 2 MTRs that Shelley had said for us to wait until tomorrow. Were they okay?
Yeah.
They're okay to file?
Yeah. Oh, yeah, they're ready to file. She had alleged the report date because she just knew they weren't going to show. So
well, it was actually 2 days ago. I forgot yesterday.
That's no big deal.
So we're just waiting on Trey to sign them up.
Well, sorry, what's that?
We're just waiting on Trey to sign them up.
Yeah, I expect they're already signed.
Well, I see we have representation in the courtroom, so. Shelley told me the PD's downstairs picking her up. Judge, just to let you know, the guy that we placed on probation earlier this afternoon came over to fill out his paperwork. Before he finished, he left. It's been over an hour since he left. So he didn't even stay to do his intake. I can't remember the guy's name now.
The one from
Wesley.
Wesley, yeah. You couldn't tell from the video, but the guy's 10 foot tall. He's a huge, tall guy.
He's a basketball
video,
player.
he looked like a little small guy.
Yeah, he's a basketball player.
Yeah.
Was. As I recall, had some talent.
You go to school here, Judge?
Yes.
Huh.
High school here.
Yeah. Don't remember him.
So what did he lack, Chris? What did he lack?
We have them fill out a 4-page document that gives us their background information. He never finished filling that out, and he walked out the door before he even met with us. We'll see if he shows back up.
He didn't even finish filling out the form. The wonderings over here were whether or not a person who exists in your office towards the front of your office might not have given him the full scope of information about what was expected of him. But
No, Shelley actually talked to him. She came down the hall to ask if he was finished with his paperwork, and he wasn't. She said, well, I'll come back and check on you in a few minutes. And then he was gone.
so it's her fault.
Yeah, we'll blame her.
Ask Danny why he didn't chase him down the street.
Terry says to ask Danny why he didn't chase him down the street.
I think we know that answer.
Well, what do we do with him?
Well, we'll give him a few days to show up, and if he doesn't, we'll deal with it that way.
Mother came with him to court last time to make sure he was just her and held his hand and was. I thought he would have done better than that.
I like it when Terry talks. It sounds like the grown-ups on the Snoopy cartoons. Wah, 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 wah.
Oh. Well, he's away from this microphone,
Right.
so it may be a bit distance distorted.
And I try to speak silently so they don't hear me.
Plus, he tries to speak silently, so nobody does hear him. And then he does say, "Wah, wah, 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 wah."
I had to change cameras in the middle of that hearing a while ago.
We
They
know
finally
that-
got us cameras to hook up to our computers, and I could close my personal computer.
Ah. The Wi-Fi over here must be having a bit of difficulty today because I think of it as buffering, but it doesn't always give us the full live streaming.
There have been times where y'all
Hold on a
chop the sound